Welcome back to Trials and Tribulations. Larry and I have been gone a minute, but we're back with a couple of new episodes. There's some important topics to discuss, especially with respect to the legal industry. In particular, every trial lawyer in the state of Florida is concerned right now about the tort reform bill that's about to be passed. And this isn't just a Florida issue. It's an issue that will affect probably many states across the country, because one of the most important factors leading up to this is that Governor Ron DeSantis, the governor of Florida, is likely to run for president. And a lot of the folks that support him, a lot of the super PACs and other political organizations, are really pushing Florida for significant tort reform. Significant reforms on the filing of lawsuits and on the protections of plaintiffs. And by putting these laws into effect and by pushing it through a supermajority in the Florida House and the Florida Congress, it may be a little bit of insight into the way he will treat similar issues on the federal level if he's ever elected president. So while it is currently a Florida-specific issue, it is something of national significance considering who the executive leader here is in the state of Florida.
Yeah, well, let's get into what tort reform is and what it means, and just the phrase is an invention. And yes, right now it's an acute issue in Florida, but it's been a national issue for a couple of decades now. So it's interesting because as we were getting ready, our production team here we were telling them we're going to talk about tort reform. No one in the room knows what tort reform means, and it's an invention. It's a very powerful tool, and you and I have had a lot of discussions about the creation of this concept. Who does it favor? Who does it punish? It's a fascinating topic, and I think now that it's really boiled to the surface in Florida, it's a great time for us to discuss it.
Yeah, it's like if you think back on the days when Karl Rove was engineering the Republican Party of George Bush and the older Republican regime. He's responsible of sort of inventing the term tort reform as a way to explain to the public how if they were to render larger verdicts in favor of plaintiffs, then that would hurt them personally by raising their insurance rates. So all of a sudden you saw a lot of commercials that would tell people how bad lawsuits were, how bad plaintiffs' lawyers were. Cases like the famous McDonald's hot coffee case are profiled nationally and have been for decades. And I'm sure any lawyer who's watching this right now who's picked a jury has asked the jury about what their thoughts are on that hot coffee case because it was so controversial. And the folks who were trying to push tort reform spun the facts of that case so much in favor of anti-victim legislation. They turned all of the facts on their head. They lied about the way that the case actually went down, and they poisoned jury pools, presumably for decades. And now, as we sit here today, folks who are asked about their feelings about lawsuits, who have never been involved in one, oftentimes feel very negatively about plaintiffs. And so it's a very effective way of turning the game against plaintiff lawyers. It makes the job of a plaintiff's lawyer or a victim very difficult. And now the laws that are trying to be passed, which will be passed in the state of Florida, are going to have a tremendous negative impact on anybody who is injured, wronged, or has any issue with an insurance company in the state.
Yeah, absolutely. So let's break it down and let's look at it from different perspectives. I mean, the plaintiff's lawyer and the defendant and the victim, that's really the tip of the spear. Let's back out a little bit and discuss who's benefiting from this. What does it actually mean? How does it relate to politics and to messaging and to the narratives and to the political agenda, primarily of the Republican Party? I think that's where the genesis of tort reform was. As we mentioned, Karl Rove was really the person behind this messaging and this phraseology, and it was extraordinarily effective, and it still is. And it's being revived right now under similar circumstances. So let's talk about that. Who's the beneficiary? Who are the beneficiaries? Why do they push for this? And why is there a response in the electorate, a positive response to it?
Well, it's the beneficiaries are primarily larger businesses and corporations because it limits their responsibility to compensate people who are wronged. Insurance companies who are paid a premium to protect their insured, but protecting their insured usually means paying out some award of damages if the insured does something wrong or the insured themselves is harmed.
That's the very essence of liability insurance, is it not?
And so by limiting the insurance company's liability or responsibility to pay damages, the insurance company still gets to collect all the same premium dollars and profit, but they don't have to pay if something goes wrong. And so some of the main points of contention here are, when it comes to tort reform, they talk about damages caps. So they want to cap and eliminate certain awards for damages. And the state of Florida used to have a damage cap on catastrophic damage awards, which, if you think about it, I mean, it's since been overturned by the Florida Supreme Court, but it was in place for years. Proponents of these types of damage caps would say you need to stop a runaway jury. You need to prevent large awards. You need to prevent frivolous lawsuits, all of which is complete garbage. And the reason it's garbage is that frivolous lawsuits, smaller claims, soft tissue injuries, none of those ever rise to the level of a cap to begin with.
Our system filters those out organically.
Right. So if you put, let's say, $1 million cap on a catastrophic injury, what you're really doing is you're telling the person who is a quadriplegic or has a person who has been killed in their family, has lost a child, that the damages for that type of case, which are the only types of cases that would really justify significant seven-figure awards, that they have no right to be compensated. The person who suffers a soft tissue injury in their neck, it's unlikely they're ever going to reach the level of the caps of these damages. And those are the types of cases that the messaging says we are trying to prevent. But everybody who makes that message knows full well that they're not being forthright and honest when they say the types of cases they're really trying to prevent. They are trying to prevent the people who have real significant injuries that need the catastrophic level of damages from ever getting what they need to survive for the rest of their lives.
So that raises a couple of points. We're getting into the details now. One thing is limiting exposure. The other thing is making it more difficult in the first instance to pursue a claim. And those are equally dangerous, are they not?
They are, for sure. For sure. And so if you talk about some of the things that Florida is looking to implement now, and you have to remember, Florida has a supermajority in the House and the Senate of Republican and a Republican governor. And again, I'm not being political because in a lot of ways, there are many things about the Republican Party that I agree with. There's some that I don't. Same with the Democrats. So for me, this is not a Republican-Democrat thing. It just so happens that tort reform is something that is primarily pushed by the Republican platform.
It's been part of the platform for a couple of decades now, more or less.
There are certainly good reasons why there are some controls that should be put on lawsuits, and I don't disagree with that. But when it comes to the type of controls that are currently being pushed, it borders on reckless and dangerous, and it's going to cause harm to people. So for one, Florida has a current law that it's been in the books for years and years and years, decades, that says if you have a claim against your own insurance company, and this is usually for hurricane-type claims or first party, they call it, when you have a claim where your insurance company is supposed to pay for your damages and they won't, and you have to sue them. So,
because what is it? An insurance policy is a contract.
Right.
You pay a premium to the insurance company, and if whatever risk is covered occurs, they're supposed to pay you.
Right. Now, what happens when they don't pay you? Currently, if, let's say, you have roof damage and the roof is going to cost you $30,000 to repair, and you have to hire a lawyer to repair that roof, the way the current law is stated is that if you have to hire a lawyer for
because
that roof,
your claim's denied,
because you say they breached the contract,
right?
Like you claim that the insurance company has the obligation to pay for your roof under the contract, and they're saying they don't want to pay for it.
That's their end of the bargain,
right?
And likely. The underlying issue here is what's their incentive to live up to their end of the bargain?
And what forces them to?
What forces them to? Because you understand, if the roof under your scenario costs $30,000 to repair, but the insurance company gets away with paying $15,000, well, what happens to that $15,000? It goes to their profits.
Exactly.
So these are just basic incentives.
So you have the regular everyday guy or girl, man or woman, who has their house damaged by a hurricane, and they have to put a new roof on their home. And the insurance company knows that they're responsible to do it, but they either drag their feet or say no. So that person's got to hire a lawyer.
Yeah, so let's use an example. Let's say that the house is damaged, and an insurance company gets the claim and says, no, that was caused by water damage not by wind. Therefore, there's a water damage exclusion in the contract.
And we're not
Now,
gonna pay.
these are common things that happen every day here.
Right. So then that person has to hire a lawyer, and that person can't afford to pay a lawyer $200, $300, $400, $500 an hour. Plus, paying that type of hourly rate would cut into the entirety of their $30,000 claim anyway, which they need to pay for their roof. So the current law says you hire that lawyer, you don't have to pay that lawyer. If the insurance company is found to have to pay, then the insurance company also has to pay the lawyer's fees for the lawyer that you hire.
Which is very significant because otherwise those fees would come out of the proceeds, which would, it could even eclipse the proceeds.
And then you can't pay for the roof. So right now the Florida legislature is trying to eliminate those one-way attorney's fees.
Which are essentially, it's like a check and balance, right?
Right. And so if that person now has that damage to the roof and this law passes, they're not going to be able to hire a lawyer to repair their roof. Therefore, the insurance company can just say, I'm not paying, and there's nobody really to stop them from denying claims. Therefore, the bank is going to tell you as a homeowner, you must have this insurance, you got to pay for it, it's very expensive. Then when it comes time for you to actually have to use that insurance, the insurance company can turn around and say, I'm not paying, and then you either have to pay for a lawyer or you don't get your damages taken care of and you have to pay for it yourself.
Yeah,
so you're paying
way,
for basically insurance that will cover you for nothing if this law goes into effect.
You're paying if you are put in a position where you have to enforce your rights through the legal process, you're paying for the lawyer one way or the other. If you're going to pay for the lawyer hourly, it's going to eat into your recovery. If you do find an attorney who's going to represent you on a contingency basis, you'll get the recovery, but part of that fee is going to come out of it because attorneys don't work for free, obviously.
Right, they're professionals.
It's a massive shift in the balance of power, and it really puts into focus in a very understandable and everyday way for people the importance of plaintiffs' lawyers in our economy, in our system, in our society, because at the end of the day, plaintiffs' lawyers are people of last resort for the everyday person to go up against large interests like insurance companies. And when the insurance companies are effectively able to lobby for these types of reforms that take away power from the everyday person, everyone is going to feel an impact.
But at the same time, they're so good at the marketing aspect of it that they make people feel that this is good for society.
It's the ultimate irony of this tort reform concept and message.
I can't tell you how many times, Larry, when I was practicing full-time, somebody would come into my office, and I usually did pretty significant cases, wrongful death, medical malpractice, and I would have somebody sitting across my desk who lost a loved one because of somebody else's negligence. This is somebody who died because other folks made errors, whether it was medical, auto, whatever the case may be. And rather than focusing on what they needed to do to get justice or to get compensation, I would hear over and over again things like, I'm not the kind of person who usually would sue somebody, or I feel really guilty about having to sue somebody. It's like they have been conditioned so much by the media and by the messaging that they actually feel that doing something that is right for their interest is wrong for society. And so they're sitting here at this crossroads. My son or my daughter died in this car accident because some guy ran a red light, but I'm not the person who sues. Like, that's just not who I am. And so I'd have to convince these folks, like, there is no person that sues. There is somebody who is wronged, and if you're wronged, you have the right to get compensated for that wrong. That's the way our system works. But by being conditioned so much against that, they're put at this crossroad where they're wondering morally if they're doing something inappropriate. And that's how this tort reform stuff really perpetuates.
That's the fallout over the last couple of decades.
It's
been
terrible.
Extraordinarily successful in that messaging and that narrative. Now, that begs the question, where's the counter narrative?
Well, they're terrible at it.
Yeah, well, so we've been speaking, and again, I want to keep this podcast apolitical. That's not what this is about. Politics play a part in it because, as you know, we were discussing this with some of our friends recently, and they described it as the perfect alignment of stars for this type of agenda to be pushed through and made into law. This isn't the first time, the first legislative session where this has been on the table. It's an every year thing. It's constant. But because there's supermajorities and a Republican governor who's now pushing this agenda because he's contemplating going on a national scale, it's the perfect alignment, and it's happening now, finally, and unfortunately. But it begs the question: where's the counter narrative? Who's out there on with a national platform explaining to people in a very understandable way what this really means?
The problem is that the people all the plaintiff lawyers and the plaintiff lawyer organizations have been on the defensive for decades. They have never really found their way to be on the offensive. And it's the best example is that when I first started practicing, I was a member of the Florida Trial Lawyers Association. That was what it was called. But the word trial lawyer became such a dirty word that the organizations rebranded
across the country,
across the entire country. So now they're not called Trial Lawyers Associations. It's now called the Florida Justice Association. It's called the New Jersey Justice Association. The California Attorneys for Consumer Rights, or whatever it's called. They're no longer called trial lawyer associations because trial lawyers equal evil in the eyes of the public.
As a result of
excellent marketing and branding by the folks who are anti-tort or are pro-tort reform and anti-lawsuit. And so that just shows how poorly the folks on our side, the folks who understand victims' rights, have failed on the marketing. And they'll all admit it, that they failed. And they're constantly on the defensive. So now because of that, and because of years of conditioning, stuff like you're seeing in Florida are happening today. And if anybody thinks that Florida is the end game here, no way. There is a push for federal, even though this is a states' rights issue, and the folks who push tort reform, ironically, are very much in the camp of state rights and state independence.
Yeah, there's some inconsistency
unless it benefits them. So when it comes to tort reform, they would prefer to put it on the federal level because it benefits them and their agenda, and they would rather punch out the states' rights and make it a federal issue. And that is what we're really moving towards. And that's very scary for victims' rights.
But again, it's also, elected officials don't act with impunity. They're elected.
Right.
So in doing this, they're confident that it'll be a popular move. And it is.
Very.
And again, it goes back to that initial narrative that's been fed to this entire country for a couple of decades now, and how extraordinarily successful it's been, to almost blinding people to how they're eroding their own rights.
Insurance companies raise rates. They make more money.
But they raise rates and they say what?
Well, no, I was going to say they raise rates, they make more money, they blame that raising of rates on plaintiff lawyers, they put that out in the media, and then the politicians push for, quote, tort reform. That's how this all rolls down.
But at the same time, they want to make it much more difficult to collect, and they want to limit how much can be collected.
Well, and let's talk a little bit about bad faith. So bad faith, in my opinion, is one of the most important aspects of your protections as a victim.
Well, let's look at it as like we talked about the first sword, so to speak, or the first powerful tool to balance out the playing field between an everyday person and a large insurance company, and that's the first party fee provision. One way. Say, all right, if you have to go up against, you're an ordinary person, everyday person, you've got to go up against this extremely large, well-funded company. We're going to give you this tool to equalize things a little bit. So that's one thing. Bad faith is another.
Yeah, so bad faith, I think, is one of the most important tools. And just real quick, I mean, I'm sure if lawyers are watching this, everyone knows bad faith, but I'll just quickly break it down is you buy a limit of insurance. Let's say you have an auto policy for $100,000 or a medical malpractice policy for $1 million. When you cause an injury or damage to somebody, that victim will have a lawyer that will demand that that amount be paid if the damages are greater than what the insurance policy would cover. So you get into a car accident, you lose a leg, the person who hit you only has $100,000 in insurance coverage. Obviously, your injury is worth well more than $100,000. So the expectation is that the insurance company will immediately pay that $100,000 because it's their obligation to protect their insured. When they don't do that, they refuse to do that, they drag their feet on doing that, it hurts the person who needs that money because of the injury. It also hurts the person who there's buying insurance because they would be the ones who would pay the excess damages above that $100,000. So the insurance company must pay the 100, or if they fail to, you can sue the insurance company for money in excess of that insurance policy.
And who's the you?
The plaintiff's lawyer or the victim on behalf by and through the plaintiff's lawyer. And that is bad faith. Bad faith is a very difficult thing to prove. It's a very difficult case to win, but it is an important tool that a victim has to make sure insurance companies act appropriately.
Again, another check and balance.
Without it, the insurance company has no incentive whatsoever to pay that $100,000 unless a jury forces them to do it. None. And I'll equate it to a government type of a case. If you sue a state government in Florida, like if you sue the state of Florida, you're capped at $100,000 per claim. I think it's actually $200,000.
Yeah, sovereign immunity.
By sovereign immunity. The state never pays the $200,000 unless they're forced to, because there is no incentive to ever do that, because they're capped, and there's nothing that will ever make them pay more than that. By doing that to an insurance company, you will destroy people's rights to get the money they need quickly. Insurance companies will have every incentive to drag cases on and force lawyers to spend a lot of time and money, and you will hurt the victims terribly.
The victims and the insured.
Yeah, both, right. The best example I have is I had a case where I had a man who was already a paraplegic, and he was being transported from his nursing home to the hospital. Or I'm sorry, from a care facility to the hospital. And he had to take one of those transport vans. The transport van puts him up in the wheelchair, puts him in the truck.
On the lift.
On the lift, and then takes him to the place and then takes him off. The lift had damage to it. The lift was broken. And so when he was getting off the lift broke, he fell, he broke his neck, and he went from being somebody who couldn't use his legs to somebody who couldn't feel anything from his neck down. He became a complete quadriplegic. Now, there's a big difference. Obviously, it's terrible to be paralyzed, but when you can't move anything from your neck down, you're bedridden for the rest of your life. And that's what happened to this guy. That transport company had $500,000 in insurance coverage, and they didn't pay it. They just sat on it and refused. And so we spent months going through litigation, trying to get the money, trying to get the lawsuit going. It was endless amount of time. And meanwhile, this guy's sitting in a nursing home, and he doesn't have the money to take care of himself. The only thing that we had to get this guy the recovery that he needed was the bad faith aspect of it. And so we ended up having to sue in federal court for bad faith and got a lot more money from him as a result. But that was only because the insurance company refused to do what they were supposed to do at the time that they were asked.
Even with that exposure.
So if that happened
even
today,
knowing that bad faith was out there in the background.
If that happened today, the guy wouldn't get more than $500,000 no matter what. And that would only be if you drag them into court and force them to pay. And it doesn't matter how inappropriate they act or how much they violate the contract with their insured, they would be capped. This is an extremely dangerous thing for anybody in the state of Florida. But people, and what I love about the way that they market this is they talk about how bad faith cases are destructive to insurance companies. They will raise rates. I practiced 18 years. I had one bad faith case ever. They're so rare.
They're very difficult to establish.
Very.
You have to thread a lot of needles through a lot of.
They're very complicated, but they use the marketing aspect of it to destroy bad faith, which makes insurance companies feel like they don't have to pay any money. And this is what's going to go through the Florida legislature.
Yeah, again, people blindly, or not blindly, but being seduced by this messaging to support something that ultimately limits their rights. It's zero sum. If you're giving up rights, you're making someone else more powerful.
And it's only going to get worse. And one of the last things that they have going on right now is they want to change Florida from a comparative negligence state to a contributory negligence.
Well, modified contributory, right? So let's explain what that is. I know we're going back to law school now and going back to the British system, but contributory negligence, the way it was in the old English system, which of course the American system is based on, is that if someone has to sue somebody else for some sort of wrong that's occurred to them, if the judge or the jury finds that they're at least 1% at fault, if they contributed at all whatsoever, even if it was just 1% compared to the other 99% of fault attributed to the defendant, they can't recover anything, which is an extraordinarily powerful dynamic in a lawsuit.
Yeah, well, if you think about, you could always try and assign 1% blame for any little thing somebody did.
Right.
Now, in Florida, they want to modify. Well, Florida is currently a comparative negligence state, which means if you get awarded $100,000 and the jury finds that you're 75% at fault, you only get $25,000 because you're reduced by the amount of fault that you have contributed to that particular accident or injury. So it's based purely on math. The way they want to change it is they want to say if you are more than 50% at fault, so 51 or 50.1% at fault, you can recover absolutely nothing. So if you're involved in any type of an accident or an incident where somebody else has wronged you, you have contributed to that, but a jury finds that you're more than 50% at fault, you will recover absolutely nothing.
Look, let's use an everyday example. Let's say that somebody is in their car, not even moving, they're still, but they don't have a seatbelt on. And someone runs a stop sign and just crashes right into them, and they're drunk and they're on drugs, and you name it. Theoretically, a jury could say, well, that person, even though you're sitting there not even moving, but you weren't wearing your seatbelt, if you would have been wearing your seatbelt, you wouldn't have been hurt as badly. So you're a little bit to blame because you should have been wearing your seatbelt. But this other guy who ran a stop sign, drunk, on drugs, whatever, he'll get off the hook a little bit. Or potentially, in this circumstance, a jury says, well, because this person wasn't wearing a seatbelt, they're 51% at fault for the amount of damages they incurred. And guess what?
They get zero.
And so this is what happens is, sure, we're using examples at a jury trial. The jury is assigning, different degrees of fault. But as you know, you have to go all the way back out and say, all right, just at the beginning of a case, when you're looking at it, you say, well, this, now that there's, you have to assess what kind of fault, if any, could be assigned to the victim. And it impacts the entire course of litigation. It can even impact someone's decision to take on a lawsuit in the first place.
Well, that's the most important part. So I actually don't, the idea of a modified contributory negligence, it doesn't completely offend me. It doesn't, because I think in most cases, people need to have some level of responsibility for their own actions. And if somebody contributes greater than everybody else to what happened to them, an argument could be made, a reasonable argument, unlike the bad faith and the one-sided attorney's fees, a reasonable argument could be made that that is a logical change to the law. The problem is when you put all of these things together and you combine them, it's not what the end result is what does it do at the front part of this? And that is, it discourages any lawyer from taking on any cases. It makes it so that victims are unable to get people to take on their cases, so they don't have that access to the courts, which were guaranteed by the Constitution. And it just slowly chisels away from people's personal and constitutional rights.
And that's the intended effect.
Right, but it's told to everybody, like I just said, I can understand why one portion of this law may make some level of sense. But when you combine them all, you are taking away one by one the rights of the individuals in favor of insurance companies and large corporations, but it's told to the public as if it's doing them a personal good, which it is not. And that's where you really have issues with this particular type of law.
Right, and I'll go back to what we're discussing is why, where's the counter narrative? And I think that the counter narrative really has to change the way that lawyers are viewed by the public by personalizing it and saying, all right, just why don't you, it's the golden rule, but put yourself in someone else's shoes. And if something happens to you, God forbid, who's going to be there to help you enforce your own rights?
Yeah. It's not until people need a lawyer that they realize how important that is to the way that our system operates. So I guess we'll see what happens in Tallahassee. The hope is that there'll be some modification, and I've been reading that they're going to try to modify some of these new laws before they go through, but right now it's looking a little dire, and I think that people need to realize that this is not a Florida issue. This is a federal issue that I'm sure we'll be talking about.
Yeah, it's a national issue. Absolutely.
Yeah. Thanks for joining us.
Thank you for joining us. This episode was sponsored by Level Ask.